Hello, you are on to Law. It's a law lecture channel that is designed to bring you law lectures on topical law issues or legal concepts in a way that makes you not only understand what they are all about, but encourage you as well to fall in love with law as a course generally. So we're happy to have you, and I am M.M. Nyim. At the end of this episode, if you love our channel, we encourage you to subscribe to it as well as click on the like button. Thank you. On this episode of Law Court, we'll be beginning the series Law of Agency, and today we'll be taking what agency is all about. The definition of agency, or what agency is all about, is therefore going to form the very first episode in this complete series of what law of agency is all about. Now, when you are looking at a law concept, the best place to start is the historical antecedent, or how that concept came about in the first instance. So the relationship called agency that has now grown into what is called the law of agency can be said to have begun when the creative deity decided that he needed a vicegerent or a representative here on earth. So the earliest records that are found, or the records that typify that which happened at that time, are to the effect that he had a council and then decided, let us make man in our own image, that he would stay on earth and have dominion over the whole of creation for his own sake. And in the course of man now living on earth, man went about to do a lot of things on behalf of the creative deity who is known as God, and those things have stood the test of time. One good example of such things is the naming of creation, which you will find in the biblical analogy, particularly in chapter 2 of the book of Genesis, to the effect that after man, who was Adam, named creation, those names have stuck up till today. He did that naming on behalf of God, and bound God, so to speak, in naming creation. So the law of agency, or the agency relationship generally, is simply a situation whereby a person who is known as the principal needs someone to act on his behalf in a certain sphere or in a certain commercial relationship, as if he, the principal, was the one doing that act or transaction, and bind him in the course of so doing such a transaction. So basically, that is what agency is all about. Now, if you have an understanding of what we are saying, then we will now go on to look at definitions that have been given by scholars, definitions that have also been given in case law. Case law are laws that are made from cases. So we are looking at definitions that have been given from certain cases by courts that have jurisdiction so to do. So before we talk about any definition, let me quickly say that there is no legal concept that has a definition that ends all definitions. So when you have this at the back of your mind, you will know that of all the definitions will be given, there is no definition that forms the authority. Like you will find in other fields of study that there will be a definition that is the standard definition. So you just know that in any definition there are certain issues that must be present in order to make your definition basically okay. We will begin by looking at the definition that is proffered by Black's Law Dictionary. edition, particularly on page 62, which defines the law of agency or agency relationship as a fiduciary relationship created by express or implied contract or by law, in which one party, the agent, may act on behalf of another party, the principal, and bind that party by words or by action. Again, the law of agency has been defined as a relationship between a principal and an agent, in which the principal confers his or her rights on the agent to act on the principal's behalf. Such a relationship is based on an agency contract. The rights and duties of the agent and principal are in accordance with the express or implied terms of the contract. From these two definitions of agency, you will find that agency is a form of contract, and it can come into effect when the parties agree, and that agreement can be either express or implied. But there is basically an agreement between two parties. The one party is called the principal. He is the one engaging the other party, called the agent, to act on his behalf, usually in a commercial transaction, and to bind him in relation to the third parties he is relating with on behalf of his principal. Now, other persons have also defined the law of the agency relationship. One of such persons is Freedman, who defined agency as the relationship that exists between two persons when one, called the agent, is considered in law to represent the other, called the principal, in such a way as to be able to effect the principal's legal position in respect of strangers to the relationship by making of contracts on the disposition of the property. And this property that he's making contracts on the disposition of, they are usually, of course, the property of the principal. He's interacting with that property in a commercial transaction with a third party who is a stranger to the principal. But because of the agreement that exists between the principal and the agent, whatever that agent does to the stranger in that transaction becomes binding on the principal, as though it was the principal that did that act by himself. So you will see that these days, with the advent of ICT, that has reduced the entire world into a global village, you will find that people are transacting businesses from one end of the world to another end, and they cannot be all over the world at the same time. So they need to have persons who are out there representing them as though they were the ones doing that thing. Now, sometimes it is not necessarily the geographical limitation that makes it imperative for someone to have a representative called an agent somewhere. Sometimes it may be that you are engaged in a transaction that needs certain skill set and you don't have the complete skill set for that. You can get someone who has the portion of skill set that you lack to act on your behalf. But if such a person was going to act on your behalf, he should have the capacity to bind you. Otherwise, the third person who is entering that transaction will have no confidence in entering that transaction, since that transaction is done without proper authority. We'll take a look at some cases that have also given voice to what agency relationship is in law. One of such cases is Oswego versus PSPLS Management Consult Limited. 2009 LPELR Supreme Court. The court heard per Ogbugu JSC that the law of agency is in sync with the definition that is given by Black's Law Dictionary, which we had earlier given. We will now take a look also at the case of Dr. Tunde Bangboye versus University of Ilorin and another. The citation is given as 1999, also reported by LPELR Supreme Court case. And this is given per Onu Jesse, who defined agency to wit to be more or less the same thing as a delegate. And indeed, the law of agency is similar to a delegate because you are more or less delegating someone to do for you what you couldn't do for yourself, and as though you are the one doing it for yourself. Several other cases have defined law of agency. Some of them are Global Soap and Detergent Industry Limited versus Bello, citation given. PHRC Limited versus Okoro, citation be given on the screen. NIPD versus Olalomi Industries Limited versus Vogue versus Gesellschaft, and lastly Modebe versus Okadigbo, citation also supplied. Now we've come to the end of this episode. We hope you enjoyed the lecture as much as we enjoyed bringing it to you. Thank you very much. Once again, I am Nyim, and if you love our lectures, please kindly click on the subscription button so that anytime we have a new episode, you will be notified. You can also give us your feedback in the comment section and click the like button as well. Thank you very much.